Hey, everybody, and welcome to this week's Trump's Trials and Tribulations. They are trialing and tribulating in an ongoing fashion, and we are going to trial and tribulate with them. Joining me from the Martha Stewart kitchen studio is the one and only Tyler McBrien. From the Scott studio, it is Roger Parloff. And here in the New York Bureau is Anna Bauer and me. It's a day off in court, so we're going to zoom out a little bit. And it's an emu shirt day, which, always means that things are fun and exciting and, large bird-like. All right, before we get started, a very important announcement. The final episode of season 2 of The Aftermath is now out. And I don't know how many of you are unaware of The Aftermath, since, for those of you who join on YouTube, there's an ad for it at the beginning of every one of these sessions. That said, according to the numbers, a lot of you have never watched The Aftermath, because there are more people who watch these live streams than there are who watch The Aftermath. And really check out, it's 2 full seasons. It's amazing. It's hosted by our colleague, Natalie Orpit. It features amazing appearances by people like Roger Parloff. Is my audio no good?
You left us for a moment.
But now I'm back. And the Aftermath is still amazing. So check it out. Lawfare presents The Aftermath. 2 full seasons now finished on whatever podcast distribution channels you use. So, Roger, I want you to get us started with all the stuff that isn't happening in South Florida, because while we've been super busy in New York, Judge Eileen Cannon has been not busy or been very busy not doing things in South Florida. Tell us about all the things she hasn't been doing.
Well, she actually, the last time we met, actually while we were recording, she was doing something. She was having a sealed teleconference, which lasted about 2 hours. It had to do with grand jury materials. And since it was sealed, I can't give a very complete description of what happened, but we suspect that some of it has to do with unsealing some things. Some of it has to do with efforts by the defense to have things that were handled by the DC grand jury brought into her court so that she can basically examine them and maybe reconsider things, including almost certainly the attorney-client rulings, some of the attorney-client rulings that were made in DC. At least 3 Trump lawyers had to testify before the DC grand jury at various points, most notably Evan Corcoran, Tim Parlatore at one point. And actually, I'm not positive of the third lawyer, if it was Jennifer Little or if it was Christina Bobb.
I believe Jennifer Little did testify before the DC grand jury.
Okay, that sounds right. And then some of it has to do with that. Anyway, that's taking time and will eventually. It could lead to some important rulings. Meanwhile, she's still appears to be going motion by motion, holding a hearing on every one. As you remember, there were 13 and not counting the motion to compel, the motion to compel is enormous, and depending on how you parse it, it's about 8 or 20 different motions. But then there's 12 of these motions to dismiss, or motions to suppress, or motion for bill of particulars. She's ruled on 5 of them, sort of. As you know, 2 of them were denied sort of without prejudice. So she's working through those. We're going to have a hearing next week, next Wednesday, on 2 things involving Nauta and De Oliveira only, because Trump's on trial still. And then on June 21st, we'll have a hearing about whether the special counsel has been properly, whether he's properly appointed and properly funded. And then the big hearing on June 24th to 26th, a 3-day hearing on defining the scope of the prosecution team, because the defense team wants more discovery, and they want to define portions of the White House, portions of NARA, the National Archives, portions of the intelligence community as all part of the prosecution team, sort of on the theory that, Trump's theory that everyone was colluding against him.
Government approach.
Yeah, that Biden was behind everything, and that Biden, and actually there's a claim that the intelligence community has been biased against him ever since the Ukraine whistleblower complaint in 2019. So, this could really balloon, but that's where we are.
And we have a hearing coming up this coming week. Which one is that?
That's the one a week from today, if that's the 22nd. That will be a motion to dismiss by Nauta for selective and vindictive prosecution. That will involve the accusations that Attorney Stanley Woodward made against the prosecutor Jay Bratt, if you remember from a couple years ago. And if you want to see more about that, I wrote an article about that on Lawfare. That has to do with allegedly Bratt bringing up a judicial nomination that Woodward had been recommended for, and Woodward understood this to mean that he was being threatened, that if he didn't persuade Nauta to plead guilty, his judicial nomination might be in doubt. And Jay Bratt has said he didn't even know Woodward had been nominated. He thought he was on the nomination committee and was, bringing that up to just as a professional thing to to show esteem for this attorney he'd never met before. Anyway, that will be one. And then there's a motion to dismiss for both of them based on insufficiency of the complaint. These are both things that, well, there is a genuine factual dispute in the obviously involving Woodward. The other one, I don't think most judges would have held a hearing about.
On the subject of Jay Bratt, I have a question, Roger. I was looking at the minute description on Pacer on the docket, which described the sealed hearing. Of course, we don't have access to know what the sealed hearing, what went on, but there is usually on the docket a little description that says who the parties were who attended, for the defense and for the prosecution. And I noticed that there was an interesting omission in terms of who made appearances at that hearing. Jay Bratt, who is typically the lead counsel, always listed first. I can't recall another time that he has not made an appearance in this case, even dating back to the investigation phase before the indictment, when I went down to Florida and went to the special master hearing before Judge Cannon. That was Jay Bratt who was there. So he's long been on this case. And I noticed that he did not make an appearance at the sealed hearing that was held the other day. And then, again, just to reiterate, looking at the docket, I couldn't find another example in which he has not made an appearance. So do you have any sense of what might be going on there? Is it just that maybe he had a doctor's appointment, or is there some kind of reason that we might wonder if Jay Bratt, because of the issues that are going on or being raised with Stanley Woodward, is there any reason why maybe he would not attend that hearing, or what's your thinking on that?
Well, I hadn't noticed his absence, so there were two other people present that were in the same meeting. As they were talking about, they would be witnesses. I would sort of be shocked if that was what it was about. But you're right. I haven't. He's not there. I don't know what it means.
All right. So let's turn now from one case where nothing's happening to another case where nothing's happening. Roger, what's going on in Tanya Chutkin's courtroom in Washington, D.C.?
Zero. Yeah, we're just waiting for the Supreme Court to decide whether it can go forward.
All right. And Anna, how about a third case where very little is going on? What's going on in Fulton County, Georgia?
Well, Ben, there's not a whole lot that's going on other than, are we frozen? Are we good?
I don't think we're frozen.
Okay. There's not a whole lot that's going on at the moment. I'm going to keep talking while while we work our video technicalities out. But there's not a whole lot going on in Fulton County. As we discussed previously, the Court of Appeals has decided to take up the disqualification appeal. There's been a number of notices of appeal that have been filed on the docket. As the Georgia Court of Appeals takes that up, we're still waiting for, the initial briefing and all of that in that matter. And I think we still don't know the panel on the Court of Appeals, but I will also admit that we have been a little bit busy with the New York trial. So I will make sure to check that and be prepared to tell you all who the potential panel is on the Georgia Court of Appeals next week. I will also mention, and I mentioned this on our dispatch, but for Trump trials listeners who do not listen to our New York trial dispatches, which you definitely should, but if you don't, one Fulton County related matter that came up yesterday at the trial is that I spotted Grant Rude, who was one of the prosecutors on the Fulton County team. He was there in the courtroom in New York taking diligent notes. I went up to him and said, "Hi, are you Grant?" And he said, "I can't comment." So I don't know, what exactly the thinking is there, other than that the Fulton County prosecution team is just watching this trial closely. It's a different defense team up here in New York than it is down in Georgia. So I'm not entirely sure, what the thinking is in terms of what they're going to get out of watching this trial as a very different fact pattern. But it seems that they are paying close attention. So that was just an interesting thing that I noticed yesterday at the trial. And that's all I got for you, Ben.
All right. So we're going to
I'm curious.
Go ahead, Tyler.
Yeah, before we turn to New York, I was wondering if any of you would like to engage in any irresponsible speculation and give any odds for the DC case going to trial before the election.
Roger, your irresponsible speculation?
Well, my speculation is unlikely that it's unlikely. I think I've sort of discussed this before, and yeah, it's just speculation, but we're running out of time. They would have to rule by early June for this to even be mathematically possible, and that would assume that they we had a majority to just send it back in some way that wouldn't require additional fact finding, that they could that might be subject to another appeal. But it's conceivable still. There's an outside shot still.
Anna, do you have irresponsible speculation on the subject?
Unlikely. I don't know if I want to put a number on it, but I guess if we're speculating irresponsibly, why not? 10 to 20%. Maybe that's too optimistic. But that's what I'm going with.
The chances are 38.6%. That is the likelihood. And you'll never know if I was right or wrong, because this has an N of 1. And if it happens, it's because it's in the 38%, 0.6%. And if it doesn't happen, it's because it's in the 61.4%. So, however it works, I'm right. All right, let's talk about New York. And I want to set up today a little bit of a debate because we actually have two conflicting sensibilities in the Lawfare New York trial team about this case. One of which is, shall we say, much more bullish on the state of the case than the other. In the bullish corner, we have Tyler McBrien, who's, tanned, rested, and ready, and thinks the prosecution has proven its case. In the bearish corner, we have Anna Bauer, who is a defense lawyer at heart and thinks the case is not all there. So, Tyler, make the case for resolved the prosecution has proven its case. A jury that will not convict on these facts are a bunch of ninnies. Go.
Well, not to disappoint you, but first a disclaimer that the cross of Michael Cohen is not yet finished. So just putting that out there first before I proceed. But as Ben said, I am feeling pretty bullish on the conviction. I think we have definitely the elements of the misdemeanor. We have, several meetings. We have one meeting in particular between Weisselberg, the CFO of the Trump Organization, Trump himself, and Cohen, with Weisselberg in hand, has the now sort of famous bank statement with his written notes on it, which laid out the entire scheme to pay back Michael Cohen for these to reimburse Michael Cohen for his payments to Stormy Daniels. So we have Trump there. We have his sign off. We also have a lot of testimony from Cohen and others that everything that Cohen did was at the direction of and for the benefit of Trump. We have this image of Trump as a micromanager, especially when it comes to money. He's so detail oriented with the money that comes in and out of his organization and his personal account, that there was one $600 Tiffany frame that he wanted to be aware of, and so that small amount of money, I guess, would signify that something as large as $130,000 would definitely be subject to his approval. We also have the fact that most of the checks actually came from his personal account, of which he was the sole signatory, which I think is a very inconvenient fact for the defense. And we also had Cohen so far holding up quite well under the cross. Again, there's still another day of it, likely tomorrow. But yeah, I think, at this point, so there's the misdemeanor. And then for the step up, we have the three theories. We have, the tax fraud written down on the statement, where it's the $180,000 was grossed up in order to pay more taxes, which again, that's a bit strange, I think, for the jury to wrap their head around. We have a lot of narrative around the election interference. So the timing, the urgency to pay Stormy Daniels in the wake of the Access Hollywood tape, and then post-election, the cover-up of that crime, which would be the step up. And then we also haven't heard as much about the FICA violation, so I'll leave that to the others. Perhaps that's a weak point that Anna wants to talk about. But yeah, now that we're nearing probably the end of the prosecution's case in chief tomorrow, possibly as early as tomorrow, I would be feeling pretty good if I were the DA's team.
All right, Anna, take the other view.
All right. Well, Ben did not warn me that we were going to basically be doing closing arguments.
I didn't warn
on
Tyler either.
Trump trials. So, and I also want to clarify that I think that, so first, as Ben said, I'm very typically, despite some of my opinions on Trump trials, because very often Trump's team has just bad arguments. I am typically someone who is quite defendants rights oriented, because before Ben Wittes, it brought me into legal journalism, I wanted to be a defense attorney. So I think that that's kind of where I am what I'm thinking about whenever I listen to this case and watch this case as the prosecution presents its case. I'm always thinking about, what are these jurors thinking? What does reasonable doubt mean? That kind of thing. That's not to say I don't think they presented a strong case. I think they have very established, beyond a reasonable doubt, that there was a conspiracy in violation of the New York election law. They presented plenty of evidence of that there was this conspiracy with AMI to have these through unlawful means, to make the hush money deals, all of that. They have established that there were these, they've established evidence that there were these illegal campaign contributions, whether it was Cohen or whether it was AMI with the McDougal deal, all of that. But then I think that the questions that I have that we've talked about on the dispatch is whether they've shown enough about Trump's intent, whether that was his intent to falsify the records as legal expenses as opposed to reimbursements, or whether at the time that those records were falsified, he himself had an intent that the falsification would be used to cover up those crimes that the prosecution seems to have established evidence of, whether that is the tax crime, the campaign contributions, the election law conspiracy. So I think that they have a lot of circumstantial evidence of that intent. And there's also this question of just logically, why else would you want these records to be falsified other than to cover up those alleged crimes? So you have a lot of that kind of stuff, but I'm just not entirely sure that they have a case that is immune to the defense in closing poking some holes in it, particularly because of the Weisselberg problem, which is that you have three people in the world who know exactly or much of what happened here regarding the reimbursement scheme. And one of them has testified, and we still have the cross-examination of him that will continue tomorrow. But the other person is Alan Weisselberg, and he will not testify, and the prosecution will not have evidence that's being admitted to help explain his absence. And there very well could be a missing witness instruction that could be favorable even to the defense. We don't know yet because we've got to wait for those jury charge instructions to happen. But I think that what a lot of the evidence that we've heard is that it was Weisselberg who came up with the mechanics of this plan, of this scheme. It was Weisselberg who went into the meeting with Trump and Cohen and showed Trump, the detailed plan, and Trump said, "Okay, I approve it." That does seem to establish that Trump caused the falsification, but it doesn't necessarily establish, I think, that he intended that those records be falsified or that they are being used to cover up the earlier crimes. Again, there's a lot of circumstantial evidence of that, and I'm not saying that that is my own view, but just thinking about maybe what some jurors are considering, that could be one area of weakness within the case. I just really think that the Weisselberg absence is kind of a big question mark over how the jurors are going to be deliberating, because it really just seems like they're going to be wondering why is it that the guy who came up with the plan that Trump then approved is not sitting there either in the witness stand or in the at the defense table next to Trump as a co-defendant. So I don't know. I mean, that's kind of my thinking, but I reserve the right to change my mind about whether it is a fully bulletproof case once the closing arguments happen and after we see the rest of this cross-examination tomorrow. I am just thinking about a few of the points that I think maybe could be areas of weakness within the prosecution, but I still think it's a strong case.
What do you think, Roger? You've been following it from mostly from news coverage and tweets from our colleagues. How do you? What's your assessment of who should be feeling good right now?
I think it's a strong case. I agree that if Judge Merchan were to give a true missing witness charge to the jury saying you can hold this against the government, against the people for not calling him, that would be devastating. I don't think he'll do that because either side could have called him in theory. And he may even go further than that. We'll have to see. I think that the rest of it is strong, and also that the jury, my guess is that, in watching this, before it started, I thought, I was embarrassed that this is the case that is going forward. I'm still disappointed this is the case that's going forward. But the facts are really scummy. And if you're a juror, you're marinating in it. If you're outside listening to surrogates, you don't get it. If you're in there listening day after day to lie after lie after lie, to all of his social media posts, listening to whole pics, even the deny, seeing the templates for how to respond, the lies about, well, it's Hillary and, it's all Hillary behind this. And that then later on you take out Hillary and you put in Joe Biden, it's all, but beyond that, you're hearing, things that are morally worse than the crime charged. You're hearing, for 10 years, Michael Cohen is working for him doing what? Being a bully, being intimidating, people into not, so Trump can bilk them, not paying intimidating vendors, intimidating contractors, intimidating press people, intimidating beauty pageant contestants who get out of line. It's really scummy stuff. And then there's the Robert Costello part. And I don't know if we even mentioned that, but, this is sort of you Mueller report fans will remember once Michael Cohen's apartment is searched. This is around April 2018. They want to keep him in the fold. First thing that happens is that Trump himself, I didn't even remember this, Trump himself calls Cohen. And that's the last time apparently they ever speak. He says something like, let me see. Don't worry, I'm the president of the United States. Everything's going to be okay. Stay tough. You're going to be okay. And then, Costello, who's the guy they hope he'll hire, begins saying these sort of Godfather-like things. Don't worry, you are loved. Sleep well tonight. You have friends in high places. There's heavy overtones of obstruction of justice. So, I just don't see the jury being disposed to turn themselves into pretzels to come up with excuses for why this lying filth. I mean, this is the impression you get: lying criminal filth. And I mean, not to put too fine a point on it, but it's quite for a case that nobody's paying attention and doesn't think is worth pursuing. It's a powerful, it packs a punch.
Yeah, I do think the case kind of creeps up on you, and that it starts out being a little case about hush money to a porn star, and then the more time you spend with it, the greasier you feel, until it kind of grabs you by the throat. I don't know. I am more agitated by it than I expected to be.
And so am I, to be clear. Like I find it to be much more compelling than I think any of us gave it credit for, having sat there every single day listening to it.
Tyler, you were trying to get in.
Oh yeah, and I think to Anna's point, just as Anna was saying that she does view this as, a lot of the behavior alleged and talked about is serious. I similarly, I am also sympathetic to the criminal justice defense argument that this is a very broad statute, and that's another conversation. But so putting that aside, to go back to the Alan Weisselberg problem, which I think Anna has a great point. I mean, there are many points in Cohen's testimony and others, McConney, others, in which they say that every penny that comes in and out of the Trump organization was controlled or overseen by Weisselberg, even if it was tracked closely by Trump as well. Weisselberg knew everything. He held the pen to the checkbook in many ways. But my problem with the Weisselberg problem is that it's to Roger's point. I think the jury will come away with the impression that Weisselberg too is guilty, but that his guilt doesn't also then absolve Trump's guilt. I don't think it's enough to raise doubt in their.
And to be clear, my argument isn't that Weisselberg is more guilty than Trump, and so therefore Trump should be, that a jury might acquit. That's not what I mean is that, the defense has been making this argument of Trump was very busy. He was transitioning to the White House. He's this guy who's a billionaire, who's got all these different things going on. And then you've got testimony that it was Weisselberg who was the one who was the money guy. Every penny went through him. He's the one who wrote up the plan with Cohen. And then he kind of waves it in front. Like they're going to be saying he just waved it in front of Trump's face, and Trump trusted Weisselberg. And so, he didn't even know basically what was going on with that, blah, blah, blah. That's going to be the argument. They've alluded to this in cross-examination, where they've been trying to portray Trump as a guy who's really busy. Of course, the prosecution has a lot of really great evidence in the record to suggest otherwise. They've got all of this testimony about Trump being detail-oriented. They've got the records showing that even down to the frame from Tiffany's, he was involved. His assistant Rona Graff and Madeline Westerhout were talking about, would he want to spend $650 on these frames from Tiffany's? And this was while he was in the White House. So the prosecution has a lot to work with in terms of countering that defense narrative. But I do just think that the defense has some things to work with in respect to, taking advantage of Weisselberg being absent from these proceedings, and then also having some favorable facts in the record that they can work with to make this kind of, it was Weisselberg who came up with this, and Trump didn't really know what was going on.
Yeah, and it's not just Weisselberg. It's also Dylan Howard, the former editor-in-chief of the National Enquirer, who's mysteriously decamped to Australia and can't be reached because of some kind of spinal injury. There do seem to be a bunch of people who have disappeared and are, suddenly unreachable, either because they're in Australia or in Rikers Island. All right.
By the way, have we explained to the reader why Weisselberg's absent? I mean, the jury won't know, but we should tell them. I mean, he's in jail, and he's in jail for perjury, and he's in jail for perjury that he committed while out on parole for 15 felonies that he pled guilty to while CFO of the Trump organization. That's why he's sort of unavailable.
Yeah. Well, so he's unavailable for strategic reasons in that respect, because he can still be hauled into court under subpoena from Rikers. But
Sure.
I think there's two strategic things going on here. One is that I think the prosecution, I don't know, but speculation, I think they assume that he's perjured himself before in respect to Trump cases, and he's a Trump loyalist, and he might perjure himself again. And in that regard, there is this separation agreement that Weisselberg has that prevents him from voluntarily speaking with prosecutors or else he will lose his remaining severance payment to the tune of $750,000. That is why the prosecution wanted to admit that into evidence. But Justice Merchan ultimately rejected that request. But it still doesn't quite explain why the prosecution didn't haul Weisselberg in before the grand jury, or, charge him and then try to flip him. There's a lot of things here that don't really make sense to me with Weisselberg, especially just with respect to why not charge him? And then you both ensure that if he doesn't cooperate and flip, then he's not going to testify because he's a co-defendant. He wouldn't be called by the defense, and he would take the fifth. And you guard against the possibility he's going to be called by the defense in that respect. But then you also have the opportunity of trying to get him to cooperate. So I don't know, Roger, what's the deal? What's your perspective?
Well, of course, they did charge him and try to get him to flip. That was the other case. And eventually he pled guilty to 15 counts and didn't flip. And then he testified again for Trump and perjured himself 3 times, really, twice in depositions and once at trial. And so I think they feel like this guy is unreachable, he's 76. He's a little old man. And he's gone to jail twice now, and you can't get blood from a stone.
I think the real question is why the defense doesn't call him.
Well, I mean,
because if the prosecution is worried that he would fall on his sword and say, I did it all, the defense should be hopeful that he might do that.
But if he does, then you get to go into the fact that Trump's CFO has pled guilty to 15 felonies plus 3 perjuries and so on. So he doesn't really do them a lot of good either, I don't think.
Yeah, and I think that's what Emil Bovee has alluded to when he was discussing the fact that Weisselberg is unavailable basically to both the defense and the prosecution. But we should talk really quickly before we go to questions about what we learned about the remaining witnesses, because that is something that we did not learn until we were able to look at the transcript after our dispatch yesterday. We've talked before in New York that it was believed that after Michael Cohen, there might be one more witness. Ben's guess was that it might be Keith Schiller. My guess was that it might be a campaign finance expert. But we learned from some of the transcripts of the sidebar conversations with Justice Merchan that, in fact, the prosecution told the judge that Michael Cohen is their last witness for their case in chief. The witness they planned to call was going to be another book publisher. It sounded like they wanted to put more excerpts from Trump's books into the record. However, they've decided not to call that additional witness. They did say, however, that they may have a rebuttal expert witness to call after the defense presents its case. That would be an expert witness that would testify to some of the campaign finance elements of the case, the campaign finance elements relating to that step up felony charge. But we also learned from the defense that they basically don't think they will have any witnesses to call. They told Justice Merchan that they don't know yet if Trump will testify, but other than Trump, they only have an expert witness on the campaign finance matters. And Todd Blanche said that that's just a possibility. He's still not even sure if they will end up calling that expert. So it could very well be that this time next week we've already had a verdict in the case, and Trump could be either a convicted criminal or a former defendant who has been acquitted.
All right, we are going to go to audience questions a bit early today because we're going to wrap a little bit early today since we have three cases in which basically nothing has happened. So we're going to not go the whole time today. Jacob, the floor is yours for the first question.
Thanks. The question is it actually possible that if he's convicted, that he will get prison time? And regardless of whether he would get prison time or not, how long does it take to do sentencing in New York courts?
So it's a good question. It is possible that he will get prison time. I don't think he will get a great deal of it. I believe the maximum sentence under this statute is in the 3 to 4 year range. Assuming the judge is not particularly angry at him for having attacked his daughter, which, we should hold on to the possibility that that's the kind of thing that really pisses off judges. I think the more expected range of sentencing is probably in the 1 to a year and a half range, but that's just kind of a guess. As to the time it takes in the New York system, I don't know the answer to that question. Normally in the federal system, you're looking at about a 12-week lag between conviction and sentencing. I don't know, do any of you, what the New York system holds for that sort of thing?
I meant to ask somebody that. I know that in the case of Weisselberg, it was about that, what you said, it was around 3 months, but lag, but I'm not sure if that's a set thing. The maximum the way it works in New York is you have, if you're sentenced to more than a year, it's an indeterminate sentence, which means you have a top number and then 1/3 of that number. So the top would be 1 1/3 to 4. And what that would mean is you actually get out after 1 1/3 because of they have parole and you almost always get it. But he would be eligible for probation because he's nonviolent first offender. And he'd be eligible also for a determinate sentence of, that means anything between 0 and 1. And you could also get 1 to 3. And so I've heard that he is a tough sentencer on white collar crime. And like Ben says, he hasn't endeared himself to the judge, and he's committed 10 contempts. So anyway, I think there is certainly a chance of incarceration.
William, the floor is yours.
Yes, sir. Everybody hear me?
Indeed.
Okay. With regard to the time frame, this morning Harry Littman sketched out two alternative schedules for the remaining New York proceedings, one of which starts with the parties arguing the law and instructions as soon as next Tuesday, closing arguments next week, or slower so that closing arguments are put off until after the 3-day Memorial holiday. Now, it seems to me a lot of people would like to see this over quickly because the more dead time there is, the more mischief may occur. Will this timing affect the odds of conviction?
So my instinct to that is probably not. That, jurors are mostly speaking pretty compliant with instructions, and the judge is, instructing them every day about the things they're not supposed to do. And we haven't had any indication that any of the judges or jurors are furtively running home and watching Lawfare Trials and Tribulations or Googling the case, though I wouldn't be totally surprised if that happened, just because of the incredible popularity of this show and the instinct to contraband of jurors everywhere. That said, I think if that's happening already, and it's unlikely to be materially different as a result of the trial going an extra week or an extra week and a half. I will say on the scheduling point, everything about this trial has moved faster than we have expected, and that's because both sides have an interest in getting things done. And so they're both erring on the side of cutting stuff. And so I think that's likely to indicate that we're going to wrap up faster than we expect. And that's not uncommon, by the way. Often when you're telling the judge how long you're going to take to try a case, you list every witness you could conceivably call. But then when you actually try it, you shave and shave and shave. What do you guys think?
I think that we get to closing statements for sure next week. I mean, we don't have court on Friday. Blanche estimates that he'll finish his cross by end of Thursday. We might have a little bit of redirect on Monday before the defense begins their case. And if the defense doesn't have their expert, a lot depends on whether that expert witness is going to testify and how long it takes. I am super doubtful that Trump is going to testify. I just think there's no way. And so I think that we get a charging conference early next week, and then we get closing statements, by as early as, well, I guess Thursday would be closing arguments, right? In that scenario.
I don't know. I think it's going to move quickly. I think everything has been moving quickly. I also don't know, is the prosecution really going to take or the defense really going to take all day tomorrow cross on Michael Cohen? They didn't exactly get a lot from the 2.5 hours that they spent on it the first day. And so, how much more of that do they do before they decide it's not worth throwing good money after bad? So I don't know, but I think err on the side of believing it's going to be quick.
Also, just a scheduling note, Anna and Ben, correct me if I'm wrong, but I saw in the chat someone had talked about the 3-day Memorial Day weekend, but I believe it's a 4-day. I think we're off.
No court on next Friday.
Right. Yeah.
Right. And that's not for Barron Trump's graduation. That's this week.
That's
right.
This
for anyone
week.
who wants to go, it's this week.
Right.
Yeah.
Roger?
By the way, yeah, I do think we should, I think the cross tomorrow might be, I'm expecting the defense to draw some blood tomorrow. I think that they are spending today regrouping, and there's just too much there. Cohen has talked himself into at least one very serious corner. And, he, in October, when he testified in Engeron's case under oath, he denied having committed a crime that he pled guilty to in 2018 and in front of a federal judge. And he said there under oath, did you lie to the federal judge? And he said, yes. So, that's going to be a bad thing. There's a lot of stuff out there. I think it's going to take the most of the day. And I think it's not going to be as, I just want to manage expectations. He escaped yesterday. I think it's going to be pretty bad tomorrow. I think.
I completely agree, but I also think it is striking that didn't happen yesterday, and that suggests both that Todd Blanche blew it, to be perfectly honest, but also that Michael Cohen is he's a more adept witness than his buffoon, than his evil clown persona would give you reason to think. Douglas, your question.
Yeah, can you hear me okay?
Indeed.
All right. Actually, my question follows right in from what you just said. Any speculation as to why Todd Blanche was doing the cross of Michael Cohen rather than Beauvais, who seems much more capable than Blanche, and any chance that they will switch gears and tomorrow it will be Beauvais?
Anna, do you have thoughts on this?
I mean, look, Todd Blanche is the Trump whisperer of that team. He is, the lead counsel. He is the one who is always in Trump's ear. Trump is always directing his attention to Todd Blanche. I think that Todd Blanche being, the one that Trump seems to like the most, even like putting aside the New York Times reporting in which Trump was apparently getting frustrated by Todd Blanche for not doing some of the things that he wanted to. In this case, I mean, it's always Todd Blanche. It doesn't matter which jurisdiction you're in, really. It's Todd Blanche who is always the one talking with Trump. And so I think that it maybe makes sense that Trump wanted the guy that he sees as his bulldog of sorts to go out there and do the cross-examination. This is all irresponsible speculation. I have no idea what the conversations are within that legal team about this particular subject. Also, I will say it's very normal for people to counsel with a big case like this to break up. You have some people, Emil Bovee, for example, was doing a lot of the cross-examinations related to the technical matters with the phone records. And then, he was assigned to another big witness with Keith Davidson. So it may have just been a, work division thing. It also could be a client management thing where Trump wanted Blanche to go out there and really, kind of dig into Michael Cohen because Blanche is the one with the relationship with Trump. Keep in mind, Blanche is the one, not Emil Bovee, who is always standing there kind of scowling at the camera whenever Trump's in the hallway talking to reporters. So he's the figurehead of this prosecution team. It makes sense that maybe he would take this. At the same time, you're right. Emil Bovee should have been in the game because he's the one who has the best cross-examination skills.
It is notable that not a single cross-examination has gone well for the defense that Emil Bovee hasn't done. Susan Neckles has a very good reputation. She did a lousy job cross-examining Stormy Daniels.
She did have a good day the first day.
Yeah, the first 2 hours she was good, but Stormy Daniels kind of regrouped and came back and kicked her ass for the next day. And that's what the jury's going to take away from it, I think, And then Todd Blanche did a very good opening argument, I think, for Trump, but he has not done well in any of the subsequent. He's not bad as an arguer, but he has not been great in front of the jury. All right, we've got some rapid fire questions that people want me to read. Do we know what the re-election prospects are for Fani Willis and Scott McAfee, Anna Bauer?
Good question. I haven't been looking at the polling situation, but I would say that they are good re-election prospects, particularly for McAfee. Fani Willis, I am curious. I mean, I've talked to some people within the legal community in Fulton County who are supporting one of her opponents. And so it does seem like he has some support, but I am not sure exactly how broad that support is. Again, I would need to look at the polls. So I would say they both have good re-election chances, but I will get back to you next week. Who asked that question?
Josh.
Josh. Okay. So Josh, remind me next week in case I forget to re-answer that question.
Josh also asks, Tyler, what exactly is the $50,000 in the New York case, i.e. the $50,000 that was added to the $130,000 to get $180,000, which was then doubled to $360,000. And then the $60,000 bonus was added to get a total of $420,000 divided by 12 to get $35,000 a month.
Well said, first of all. And second of all, I think this was actually a great subplot in the story. Ben and I were talking about it after court one day. This would be, I believe, the payment to Red Finch for some IT services. This was just a classic squeeze the vendors situation in the Trump organization. I believe what happened, this is based on Cohen's testimony, was that this IT consulting firm called Red Finch, which Cohen actually knew the CEO of, or the head of it. They were doing some services in terms of buying domains and what was it?
It was rigging polls, I think.
Yeah, right, exactly. And just in classic Trump org fashion, they were finding ways not to pay Red Finch. I think Cohen had this great phrase, like, Trump was not satisfied that they rendered the services that he wanted. And they essentially Trump didn't want to pay them. And so, as probably happened many times in Cohen's illustrious 10-year career, he ended up, I believe, paying them himself because he had a personal relationship with the head of Red Finch, and he also needed Red Finch to do future work for the Trump organization. But the best part about this was that it turns out that he didn't actually even give all the $50,000 to Red Finch. He kept most of it for himself.
That was a very interesting moment.
Yeah, and actually he skimmed a lot. I mean, I think he got reimbursed 50 and he paid 13 or something. I mean, he actually made out pretty well on that. So fleecing the Trump organization in the name of loyalty. All right, anonymous attendee asks, will the fact that the Trump organization is paying certain witnesses' lawyers ever be raised as an issue of credibility? For example, if Keith Schiller gets up to testify, how credible can he possibly be? So the answer to this question is, this is why at the beginning of every direct examination of these witnesses, they ask, are you here with your lawyer, or who's paying your lawyers? And they all say the Trump organization, except Hope Hicks, who says, I think her lawyer is pro bono, I think. By the way,
Lester Hout as well, I think.
To all those folks out there who do pro bono legal services to somebody who's, do it for the poor, man, not to the, or to the cash-strapped nonprofits like Lawfare. Hope Hicks doesn't need pro bono legal services. That's just saying. They always inquire about this, and the reason is so that you can then argue to the jury if you see fit. Of course, Anna Bauer, didn't testify, said only nice things about Donald Trump. Of course, she testified that that she had a wonderful experience working at the Trump Organization. Her legal fees are being paid by the Trump Organization, but even she admits that blah, 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 and blah, 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 and blah, blah, blah. So that's how it comes in. You're not allowed to say, you're not really allowed to interfere with somebody's choice of a lawyer or somebody's choice of how the lawyer gets paid. That's between the lawyer and the client. But you are allowed to adduce it in front of a jury and make whatever arguments you can make based on it. Is that a fair summary, guys?
Mm-hmm.
Anonymous attendee also asks, what was the point with Blanche asking about Cohen's 2 phones being seized? Who wants to take this one?
Well, I mean, I'll just say broadly that they have been trying to thread this argument and I think maybe you can follow up if I'm not getting it right, but they've been trying to thread this argument through cross-examination that some of the phone records or the recordings specifically that were on Michael Cohen's phone, particularly the McDougal recording or the Keith Davidson recordings that Michael Cohen made, may have been, edited or corrupted in some way because of different issues with chains of custody where, his phones were seized and then he had them back and then the Manhattan DA's office got them later. And so they're trying to make this argument that is sowing the seeds of doubt about whether or not those recordings were in some way manipulated. Ben, is that what you got as well?
Yeah, that's exactly right. So the prosecution has this awkward fact, and it is awkward, that the feds seized these phones, they used them for however long they had them, and then they returned them to Michael Cohen, who had them sitting in his apartment for, 2 or 3 years or something, before he then voluntarily turns them over to the New York AG's office. It is conceivable that all kinds of things could have happened in those 2 to 3 years or however long it was. And the defense's job is to raise all kinds of doubts about whether that recording
we've
manipulated in some way. So that's about a variety of little attacks that are based on that. All right, 2 more questions. WH asks, can you all estimate how much longer you expect this trial to go? Could we get a decision before Memorial Day? We've kind of already answered that, but I'm thinking about a week and a half. Do you have a guess, Anna?
Yeah, I think that's right, about a week and a half. It might be optimistic to think that, I think I said this time next week, but I was thinking that this was Thursday. It's actually Wednesday. I think that it's about a week and a half, probably after Memorial Day. But if the defense has no case to put on, I mean, we could feasibly have a verdict by the end of next Thursday, depending on if the jury has a decision to make this pretty quick or if they'll take a longer time. But, week and a half sounds good.
Tyler, Roger?
Same answer. I mean, we have 4 days of court before Memorial Day, which seems tight, but seems possible. Everything's been going quickly.
Roger?
I'll defer to them.
I will just say that a huge amount depends how long the jury is going to deliberate. If you have one of these juries that's going to walk in and sit around and say guilty, that can happen really quickly. On the other hand, a jury that's divided and has to argue itself to a point, that can take a long time, and juries can stay out for a while. And so a lot depends on that. Last question of the day from anonymous attendee. I'm aware that all juries are different, but given that, does the verdict in the E. Jean Carroll case, which was also a jury trial, give us any insight into the willingness of all 12 jurors to find Trump guilty. Let's do a quick runaround about this. Tyler, give us your thoughts.
I mean, yes, I think a guilty verdict is possible. I know that's not exactly the question, but
No is my answer. Absolutely not. It's a different jury, different facts. And if the jury is taking its responsibility seriously, then the E. Jean Carroll verdict has absolutely no bearing on, and it doesn't really give us much insight into how the jury will find in this case.
Roger, what do you think?
Agree with Anna.
I also agree with Anna for an additional reason, which is the E. Jean Carroll case is a civil verdict, and therefore the standard of evidence is way lower. I do, however, think it is striking that every single one of these cases in New York, in either state or federal court, that has gone to verdict, and there are a bunch of them now. There's the Trump organization case, criminal case. There's the E. Jean Carroll cases. There's the giant civil fraud case. Whether they're bench trials or jury trials, the ones that have gone to verdict have all, I think without exception, been verdicts against Trump. And so I think you can say, I don't know what to conclusion to draw from that. I wouldn't draw it about jury behavior, but I would say that the more exposure people have to what Roger calls the incredible filth, the more disgusted they tend to get. And I do think that's something. So we're going to leave it there. Oh, sorry, Anna.
I was going to say, before we wrap, in my defense, I didn't really understand the question, and I will also side with Anna, which I think means that Anna has emerged victorious in today's debate.
All right. We are going to leave it there. We will be back tomorrow for our regular video/audio dispatch. We're going to be back next Wednesday at this time for Trump Trials and Tribulations. Maybe we'll have some activity in some other court. Maybe Judge Eileen Cannon will bestir herself to do something. Probably not. We may have some Fulton County stuff to talk about. In the meantime, y'all, and this is not directed at the beloved people who are here in the chat, in the Greek chorus, in the Zoom, but if you're watching this on YouTube, consider clicking that little donate button to support Lawfare's coverage, or better yet, go to lawfaremedia.org/support. Become a material supporter of Lawfare. Join us in the inner circle in this webinar, where you can be part of the internal chat. You can ask questions. You can come on the show yourself or ask me to read them for you. Because, Lawfare, unlike all these other publications, we are exactly as robust in this space as you guys let us be. And we grow according to user demand. And right now we are, I think, in demand, very much in demand. But we are also stretched thin, and like none of us is sleeping a whole lot. And so, become a material supporter of Lawfare and help Tyler get some sleep.
And also, we saw some of you making comments about the electrical tape that was holding up the Lawfare sign in the background of Tyler's video in one of our dispatches. And so if you want to support our fund to hang things not with electrical tape, you can support the fundraiser.
I would also just point out that that was a joke, that people had been criticizing our background, so we hung stuff with electrical tape. And for those of you who didn't get it, all right, we're going to leave it there. Roger Parloff from the Sconce studio, Martha Stewart studio, Tyler McBrien, and from the New York Bureau, the Law